Well, good afternoon. Thank you for joining us at today's webinar, which is how to handle expensive ADA website accessibility claims. To my left is Nicole Smith, my partner here at Rumberger Kirk Caldwell. Hopefully today we'll be able to give you a good bit of information on why these claims are of concern and a little bit of information on how to address them. First, before we get going, we want to thank the Florida Restaurant and Lodging Association, and in particular Dan Murphy and Vanessa, for helping us to coordinate and put on this webinar. We're very excited to do it, and we think it's a great idea to bring this information to FRLA members so that they can be informed about what is a rapidly developing area in litigation. Quickly, for people who want to ask questions, we've tried to set up a method to communicate with us that doesn't really disrupt the ability to listen for everyone else and allows us to see your questions. So we have up on the screen a way to send in a question essentially in real time to us, and it will be answered by likely Nicole, possibly me. So the website is questions, it's pretty simple, questions@rumberger.com. And we are monitoring the questions. We're monitoring the website, the email exchange, and we'll take those questions and we'll ask them during the course of the presentation, time permitting. And if for some reason we run out of time, well, we'll respond separately afterwards. Just the last point before we get rolling. This is going to cover the basics a little bit because this is an unfamiliar area for a lot of people, and some people who are watching this webinar may have a higher degree of sophistication in the ADA website accessibility world. But we want to make this level for everyone. We want it to be informative for everyone. So we're going to start with a little bit of background and then move into this very specifics and talk about some different concepts of how to deal with these challenges. All right, so let's get going. So the method we're going to use for this is question and answer, and I'm going to play question asker, and Nicole's going to go ahead and give us the answers and the benefit of her extensive experience in the area. So let's start with question number one, Nicole, which is, why is this issue one that is important at this time for businesses in the restaurant and lodging sector?
Well, Jacey, this is a really, as you said, rapidly growing area. In fact, just in the last year and a half or so, over 100 ADA website lawsuits have been filed in the Southern District of Florida. So Florida is really the new battleground state. I think, in fact, we have just recently gone to #1 in terms of the number of filings.
That's an ignominious
correct
reputation, claim to fame, I think.
A lot of activity down here. Previously, the litigation had been centered in Pennsylvania, New York, and California, but now we're seeing it in Florida. And almost all of the filings have been filed by one particular plaintiff's firm, the law office of Scott Dinnan, and he's filing it on behalf of two individuals, two plaintiffs, Juan Carlos Gil and Andres Gomez, both of whom claim to be plaintiffs with visual impairments. They're legally blind, and they claim that they cannot access the defendant company's websites. So the reason it's particularly important to speak to this audience today is because of the makeup of the target defendants that we're seeing in these lawsuits. As you can see from this graph here, over 63% of these filings have been against defendants who are in retail, and then hospitality is after that, and we've got the restaurants. So these are particularly easy targets because oftentimes there's a brick and mortar location, there's a store, and then there's also a website where you might offer your products or your services, and they can be connected. So the plaintiffs know that, and so they're making these lawsuits, these claims against the industry, the retail and the hospitality industry.
And I know you're going to touch a little on this later, but it seems that you've already hit on the fact there has to be a nexus, there has to be a physical location requirement here in the state, and that's going to come up. So it would seem that that would make lodging, restaurants ripe on that front, and then the active website, and off to the races.
Absolutely, and we'll go into what the plaintiff needs to allege in the complaint in order to state a claim. But essentially, yes, there's got to be that nexus between the brick and mortar and the website. And keep in mind, Jacey, even though these filings are right now only in the Southern District of Florida, from what we've seen, we anticipate that other entrepreneurial plaintiffs are going to see this wave of litigation, and they're going to be filing claims in other parts of Florida and Georgia and Alabama, which make up the 11th Circuit.
And they're going to go to the easiest first, the most obvious choices first, right?
Correct.
Okay,
Correct.
and that is the way here. Okay, so you're talking about litigation. You say litigation is ongoing, and obviously you're involved in some of those cases. So how are most defendants handling these cases?
Well, it's interesting. A lot of people and a lot of my clients in particular first see these claims and they say, this can't be possible. Why would a website have to be accessible under the ADA? It doesn't necessarily make sense in what we know of the cyber world and the ADA.
Right.
But in fact, most defendants are settling these claims. We've been monitoring these claims for the last year. I can tell you that a couple of the defendants, well, more than a couple, a few, have filed motions to dismiss, but then thereafter have settled. I think there's one motion for judgment on the pleadings that is now pending, and we'll see if that particular defendant pursues it, but they're settling. So that might be surprising. And so some of the reasons that we think that's happening is obviously to avoid litigation. We often say as lawyers, we're the one that reap the benefits of litigation, but nobody else. So it's cheaper, it's faster, it's easier to avoid the litigation, so that's understandable. And we're going to talk about today the confusing legal landscape that exists. There is some contradictory case law. There's some inaction by the DOJ. They still have not issued the regulations that pertain to websites. So it's rather confusing. So we hope to make some sense out of it for you today so that you can be prepared if indeed you are the target of one of these lawsuits. And lastly, we believe that our clients and the other defendants in these lawsuits, that they're settling because it does make good business sense. And so we'll talk about that today as well.
Okay, so let's kind of start at the very basics. I'm a business person, and I want to know what are the ADA regulations that I need to comply with? I mean, show me the rules, and I'm going to do my best to comply.
Right. So as you mentioned, we're going to go back to the basics here because some folks might think they know the ADA, but we want to make sure that they really understand what provisions are and are not at play today.
Not like this.
Not like this,
Got
right. So Title III of the ADA applies to any private entity that is considered a public accommodation. So that includes the restaurants, the retail stores, shopping centers, grocery stores, hotels. So there's 12 categories. Probably most of the audience today is going to be within these categories that are a private entity and that constitute a public accommodation.
Absolutely.
So at its very foundation, what the ADA provides is that no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of any place of public accommodation. And again, whether the business's website is a public accommodation becomes the key question. So we know historically, probably many of you have been the subject of a traditional ADA lawsuit. And so your brick and mortar locations unquestionably are public accommodations. But what the courts grapple with is whether your websites are going to be considered public accommodations.
Because at first blush, I can think, watching this presentation, you think, how in the world could a website, which is out there in cyberspace somewhere, be a public accommodation?
That's right.
Explain that. How is that the case?
Well, right now, the courts are split on that question, but you should know that the 3rd, the 6th, the 9th, and the 11th, which is us, Florida, Georgia, and Alabama, those circuits have held that to be subject to the ADA, the website must have a sufficient nexus to the services of the actual brick and mortar location. So we kind of gave that preview at the outset. And nexus means there has to be some kind of connection between the brick and mortar and the website. So some of your services, for example, you could be selling a jacket on your website and it's offered for sale at the actual store, and the person can view the jacket, maybe buy it online, go to the store to view it. Plaintiffs are alleging that even the location finders, find the restaurant, find the hotel near you, they're trying to find any kind of connection, any kind of nexus between the brick and mortar location and your websites. So if you right now in the 11th Circuit are a website only business, then you are not subject to the ADA. Only the brick and mortar store is considered the public accommodation itself, not the website. But if there's that nexus, then the website is drawn in and can be subject to one of these claims.
And just to clarify quickly on that point, does that mean if you have a website only presence, only out in cyberspace, you don't have to comply, but there may be business reasons that we'll touch upon later to comply anyways?
Correct.
Okay.
If you are in the circuits that we just discussed, if you are a national presence, then you'll see the answer becomes a little bit more complicated because the courts are split. But for where we are right now in Florida, and we may have some folks in Georgia as well, in Alabama, that are listening today. So this is the controlling precedent in the 11th Circuit. Rendon is the case where, if you remember the game show Who Wants to Be a Millionaire a few years back.
What a show.
What a show. So they had apparently, in order to make it onto the show, they had a fast finger dialing system where you literally would have to show how fast you can dial on your phone, and then you could qualify to make it onto this game show. So the 11th Circuit and that court held that the plaintiffs indeed, and plaintiffs in that case, it was one individual and then a nonprofit group on behalf of several disabled individuals who suffered from, they had upper body mobility issues, so they couldn't do the fast finger dial. Mm-hmm. So they said that they were discriminated against. And the court there then did say that they demonstrated a claim because there was a nexus between the challenge service and the public accommodation. Interestingly, it was the studio website, the studio audience and where the game show was filmed that was deemed to be the public accommodation, and then the challenge service there was the phone dialing. So that sort of set the stage. Later that year in 2002, the Southern District of Florida also rendered a decision, which seems a little contradictory at first blush, but that was Southwest Airlines website, which, if you remember back then, they were actually one of the pioneers into the website business. I think it was the first airline that had one. And so plaintiffs there were claiming that Southwest's virtual ticket counter was not accessible. And the Southern District found that there was not a nexus between the airline's website and the physical concrete place, that there were not services that were provided on the virtual website that they couldn't actually get at the ticket counter, and that therefore there was not a nexus. So as you can see, it can be rather confusing, but for your purposes, we want to be more like the Southwest airline virtual ticket counter and less like the TV studio with the game show.
And accessibility.
And accessibility.
Understood.
Right. So I told you earlier that, in answer to your question, if you're a website only business, are you safe? The answer is it depends. It depends where you are. So if you're in the First, Second, and Seventh Circuits, those places have held that a place of public accommodation is not limited to the physical structure, and that the websites are subject to the ADA. So
the plot thickens.
The plot thickens.
And there's been nothing at the Supreme Court level to clarify this. Nothing's pending.
Nothing is pending.
Okay. All right. Before we get into drill into the specifics which are coming, to me, if I go to look at the law, I can't find anything that's going to help me and guide me. I go to look next at cases, what the courts are saying, and I'm not getting necessarily a uniform answer, though I'm getting some answers. I'm going to go to regulations. So I'm hoping here that there's a set of regulations I can look to and get guidance as to what should be my best practices. Do we have that in place here with ADA website accessibility in particular?
Not yet. Unfortunately, for those of you who are familiar with this issue, you've been waiting a long time and you're still waiting for those regulations. The Department of Justice started working on this many years ago. In 2010, it issued a notice of proposed rulemaking to establish exactly what you're saying, the standards, the guidelines, so that entities know what the rules of the game, are going to be. However, they have yet to issue those guidelines. In fact, earlier this year in May, they issued a supplemental notice of proposed rulemaking that dealt just with public entities under Title II, so that's your state and your local governments. So we anticipate that DOJ is going to be issuing the regulations for Title II next year, if they stay on track. They haven't in the past. Let's see if this time it goes forward. So there's some uncertainty still. But if the path moves forward, which we expect it will, then the public entities will have the regulations next year, and DOJ has signaled that they will then use the Title II regulations as a template for Title III, which is what we are here today, which are the private business entities that are public accommodations. So unfortunately, though, even though there are not regulations, this has not stopped DOJ from pursuing enforcement action. So this is why it's become really confusing. And I've had many of my clients look at me and say, wait a minute, you're telling me that the government has not issued rules, yet they're going after us for it. And unfortunately, that has been the case. In fact, just last year, the DOJ settled with Carnival, requiring that Carnival's websites and mobile applications comply with what's called the Web Content Accessibility Guidelines, WCAG for short. There are different levels of compliance. 2.0 level A, for example, is less stringent than level AA. So at this point, DOJ has signaled that WCAG, that they are going to be the guidelines. There is some discussion as to whether it's going to be level A or level AA, so yet another area of confusion. But if you're going to go through and try to make your website accessible, we are recommending at this point to our clients that it makes sense to just do the higher level of compliance, the level AA, because then you're going to cover your bases. And for a lot of reasons, it's easier to do it now than down the road. Nonprofits have also entered this sphere. They're also bringing lawsuits on behalf of disabled individuals. These get a lot of publicity, as you can expect. So that's another aspect that we'll talk about. Do you really want to be on the wrong side of one of these claims? Do you want to be a good steward of your customers, and they can bring up that you're not and your websites are not?
The whole reputational component.
You got it. You got it. So it's
understood.
That's the status right now.
Okay. So we've got a murky picture. I think we've laid that out. So we've talked about the history. We've talked about why it is we're here and why we're giving a webinar on this subject at this point in time, because there's a lot of questions, a lot of uncertainty. So let's try to offer some clarity. Let's try to offer some answers. Start off with businesses that are listening to this, that are in the restaurant or hospitality lodging sectors. What are some tips that you can offer them that are concrete ways for them to begin to wrap their arms around and deal with the issues that are being presented in these lawsuits?
Now that we're all on the same page with the background, we can get into some of the nuts and bolts. Obviously, consult with your attorney to understand the risks that your business face, because your particular business might be different than the next one. And you can plan how to minimize your liability. Obviously, we are handling these cases for many of our clients who have been hit here in South Florida. So we're glad to speak to members of the FRLA, or if you have an attorney that is educated, and there's not that many of them, but if you have one, speak to that person. Consider hiring a digital accessibility expert. And what that means—
Sounds fancy.
Sounds fancy.
Sounds pricey.
Yeah, so think of a traditional brick and mortar case. You typically do have to hire an expert to go out and look at your restaurant, look at your hotel, and say, the toilet paper roll needs to be X number of inches from this place, and it's not, and we need to measure this. You're not the one that is necessarily going to know how to comply. So it's the same thing here in the digital realm. There are experts who specialize in this area of digital accessibility. There are not that many of them, and that's actually one of the issues that DOJ asked for comments about in its latest supplemental notice of proposed rulemaking is, I think it understands that once they issue these regulations, if there's going to be a mass run on these digital accessibility experts and there's a limited number of them out there, how is this going to actually happen? So
they end up with a drain on available assets.
You got it. You got it. So that's one reason why we are telling our clients, we think the writing is on the wall one way or another. This is coming down the pike. We can't tell you exactly when, but it makes sense from business perspective. If you can hire the best people now, they're going to be charging less than when there's the actual regulations on the books and everybody's knocking at their door saying, we want to use you.
Absolutely.
So we've been working with a particular company. We're glad to share that information if you want to contact us afterwards. There are many of them out there, and we don't necessarily say use this company, but we have found that they do good work. They've got engineers that are disabled, that have, for example, sight impairments. And I think I mentioned earlier that the lawsuits that are being brought, for those of you that don't understand what that means, if somebody is blind, how do they read the website? There is software that provides an interface between your website and the individual's digital accessibility device, which is like a screen reader, like JAWS.
Right.
So if your website does not have the correct coding, it can't interface with the person's screen reader. So what these digital accessibility experts do is that they go out and they will audit your website and determine where you've got barriers to accessibility. So that's why it might be an important consideration to hire one of these folks, because at this stage in the game, there may be some limitations to what your own internal team can do, but we do want to talk about that from a beginning standpoint. If you're a smaller shop and you can't hire, you don't have the $20,000, $30,000 budget, which a lot of people, even the bigger companies, didn't expect to spend that kind of money, and they're trying to scramble to find this money in their budgets to become compliant. But if you're a smaller shop, you may be wondering, well, what am I supposed to do? I can't hire one of these experts. So we do want to provide you with some tips as to what we can do here.
That would be very helpful. And just to clarify, the group that we work with, they're also from another round of litigation outside of Florida. They're litigation savvy. They've done this drill before, right?
Right. Some of them, the expert, yes.
Yes.
Oh, yes. The expert that we've been working with has assisted in some of these DOJ actions. They have participated in the private lawsuits. So absolutely, you want somebody who understands what the WCAG standards are and how to make sure that your company is able to implement the remediation.
Okay, so now we're going to talk about, if I'm a smaller business, or even not, but particularly with an emphasis on a smaller business, what are some things that can be done in the near term to help? Is that where we're going? Okay.
Yes. So you don't have the money for a big, outside expert to come in and fix everything, which if you have the money to do that, that's highly recommended because they make it easy for you. But if you don't, here are just some tips that there are requirements under the WCAG guidelines, and there's some of the, what I call the low-hanging fruit, some of the more obvious barriers that these websites have.
Okay.
So for example, if you have an image, a picture on your website, a person that uses one of these screen readers that we just talked about, the JAWS, that is not going to be understood by their technology. In order for them to know what is appearing on the screen, and frankly, it's maybe your product that you want to sell, maybe it's that jacket that you're trying to sell, you need to tag it with an alt tag or a longer description so that it says black leather bomber jacket. And then that person's screen reader is able to interface and understand by virtue of that description what it is, that your website's showing.
And let me stop and ask you this question, and we're talking about people who are in the lodging business. The same applies to maybe a room description.
Good point.
Or room pricing.
Yes.
And I think if we're talking about someone who's in the restaurant business, are we looking at menus and perhaps menu information, whatever menu information is available, location information?
Absolutely.
Okay. So,
all of the above. So think of how many different services that your website is trying to provide to your customer. It may not be able to reach the disabled customer because of that issue. So if you're showing a picture of a beautiful hotel room, if you don't have a description of it, that person's not going to be able to understand what it is you're offering, and we'll talk more about the good business part, but you could be losing that person then to perhaps the next hotel chain that does provide this.
And that was a great point, and that's what I was about to ask. So even though the room is fully accessible,
right. So many of
you're
us
not somehow bulked up against the website issue.
Correct. And as we know, there are so many folks out there that want to use the website, and so like you mentioned, we have taken great pains, many of our businesses over the years, to make sure that we provide the brick and mortar space to be accessible. So this is sort of the next generation. You know, think of it as a way of communicating with your potential clients. You want to make sure that they can reach you, not just once they arrive at your physical space, but you want to be able to get them in the first place. So that's one very basic tip. If you're posting documents onto your website, if you post just an electronic version of it, let's say a PDF, which some of us would do, again, that's just a concrete barrier to these screen readers. They're not going to be able to understand it. Text is the key for these screen readers. So you might want to provide an alternate document that is accessible, or just make the document accessible in the first place rather than in one of these other formats.
So when you say that, just to pause, for someone who doesn't, like maybe me, who doesn't understand what you're talking about when you say make a text version available, what does that mean? Because to me, if I can have something in a PDF, that's easy. I can use it, I can put it up on a website, I can send it to people.
Right. You've seen like HTML, text.
I have seen that. Yeah.
So that might not mean anything to you, but to a screen reader, right? So if you're listing all of your prices and you have people click and it's a PDF document, they're not going to be able to read that because it's not in a text format. So the screen reader literally will read it. And then there's, you know, things that you need to make sure that you do with the actual text so that the screen reader doesn't get confused. Like acronyms, you don't want to necessarily, you want to make sure you use the proper punctuation. Otherwise, it can just read it as one word rather than an acronym. So there are different tips that you're going to have to make sure that you can comply with. But the most important part is that they have to be text. They can't just be the images. They can't just be the electronic document. They have to be text. So that's the important message here. And then that's sort of the level A compliance, then we can go to level AA, but these are some basic ones. Obviously, when we look at a website, you and I can see it easily, but the next person who might have some sort of a disability, poor eyesight, for example, we've got many older folks in Florida, especially. So you want to make sure that when you set up your website, even if your web designer wants it to be, you know, in the marketing department, a certain color, a certain font, you want to allow it, the user's browser operating system to adjust that so that maybe they see better on a white or a black background with white lettering or yellow lettering. There's things that they can do on their end that can adjust it so that they can see better. So that's just a very easy one. Keyboard accessibility is a big one, and it might not sound like it to your eye because we can click around easily on our mouse. But imagine if you're an older person, or if you're a person with upper, extremity mobility issues, you may not be able to click. And sometimes we have the click here, and it's a bullseye target that's big, and the person can't quite get it, and you want them to be able to go to that place. But if you make it too hard with the mouse clicking all over the place, they're not going to be able to reach it. So your keyboard, and there's different types of keyboards that people can buy, and they can just press the keyboard in a much easier way so that they can navigate through your website rather than have the dreaded mouse, which again, not a problem for you and I, but
but it's a barrier to accessibility for someone else.
For someone else, exactly. And, you know, if you've got a friend or a loved one that has one of these conditions, this isn't news to you, but there are some of us, you know, and people that sit around that design these websites that don't necessarily consider this. So this is important to think about these things.
Let me pause one more time, and just in case there are questions, because we see from the webinar that people may be raising their hand to ask questions, but because of the format that we're using, we're a little limited in our ability to slide over and read those questions. Please, again, feel free to use the email address, and we're reading them in real time as we're presenting the webinar, which is questions, it's plural, questions@rumberger.com. I just wanted to interject with that again, because we want to be able to get your questions live.
Good, thank you. Lastly, here we need audio descriptions, you know, closed captioning from TV. If you're going to post a video up, somebody that has a hearing issue may not be able to hear the video, but they can see it. So you need to have, you know, the captioning there as well, which is very, very helpful for folks.
Absolutely. And as an aside, I know because I actually am helping someone with the creation of a game for the visually impaired right now, the audio piece is a critical component.
Critical component.
And something that a lot of websites probably don't really consider that much. Some do, but some probably don't, because they don't necessarily emphasize that audio component to the overall of the website.
Sure. Yeah.
So here it becomes more critical, though.
It does. It does. And what you're saying kind of speaks to the issue people have now, is if it's not considered from a design standpoint, you know, a lot of people have to go in after they have the existing website and try to retrofit, which can become more expensive. So sometimes it's easier to start from scratch. I'm not recommending that you do that, but it may be, if it's a very complex site, trying to retrofit it could be more complex,
and so I think
more expensive.
If there's advice for people on the phone who have not yet gone into the establishment of a website, they're in the thinking about, or maybe the early creation, but nothing out there in cyberspace yet, I think it sounds to me like you're saying your recommendation is engineer that in at the outset if you can.
If you can. Your life will be so much easier going forward. Blinking, flashing features, you know, we all have businesses, we're trying to sell our products or services. Make sure you can turn that off, those functions, because if somebody has a seizure disorder or a visual problem, it can be very difficult. And as we mentioned earlier, if you're trying to sell the hotel room and it's saying $99, $200, and it's blinking, they might just shut off your page and go to your competitor's page because it's hard for them to see that. Pages with timed responses, I think the one that I always think of are the when you try to buy tickets for a concert and you did put it in really, really quick, or you're going to lose your front, you know, row seats. These can be very difficult for people that may be a little bit slower than you or me in trying to fill out these forms. You want to allow people time to do that. So if you can avoid the timed responses, that's very helpful. And web-based accessibility evaluations. You're probably wondering, what the heck is that?
I have no idea. What does that mean?
So if you just Googled website accessibility, probably you're going to come up with dozens and dozens of vendors that are offering their services. And basically it's automated tools that you can put your URL in, you know, your web address, and it will digitally test your website. Now, it's in theory a good idea. We can't vouch for any particular one. I will tell you there's some that are better than others. But there are limitations as well that we want you to be aware of. For example, we haven't, in this day and age, at least in this sphere, replaced humans with computers. So the digital automated tools, they may be able to find 20, 25% of your accessibility issues on your website, but it's still not going to replace what a human could do with real live testing. So not saying don't do it. I think it's a good starting point, but just be aware you can't, you know, go to one of these websites, put your URL and say, okay, we're done. Been there, done that, we're fixed.
So that is not going to necessarily prevent someone from making a claim that the
Correct.
website is, for ADA purposes, inaccessible.
That's absolutely right. That's absolutely right. Because all they have to do is sit with their screen reader, try to do something on your website, and you may have fixed some of the issues that the accessibility tool told you to, but just be aware that it's not going to solve all of the problems. So to that end, and we're sort of increasing now here in terms of level of compliance and sophistication, but if you do have an IT team, I know not everybody does, but if you do have in-house people,
Or even external.
or external access to an IT team, make sure that you train at least one individual so that if you get contacted by a person who is having issues accessing your website, that your person can try to, at least understands what the issue is and can try to address it or put it on your radar so that you know that this is an accessibility issue that we need to understand, and we need to make a decision whether we're going to try to remediate it. And I can tell you that most of the settlements that we are working on right now, and DOJ's as well, require some sort of customer service component. So whether it's a website, a 1-800 number, something that people with issues with your website can contact the company and say, hey, I'm not able to order this product. Can you help me out?
Well, how's that last one affixed if there's a phone number?
Well, it kind of links into the next one that we're going to talk about.
Great,
no pun intended, accessibility link statement. So what these settlements also are providing for is that companies set up what's called an accessibility link or an accessibility statement. And included in that needs to be a 1-800 number or an email address so that the person can contact. And what you all out there, and Jacey, I want everybody to understand, this is a long-winded answer to your question, is that these fixes are not required to happen overnight, right? So most of the settlements that we're working on and we're seeing out there in the litigation realm are allowing folks a couple of years actually to become compliant with those standards we talked about, the WCAG standard. So it's an evolution. So just the fact that you have somebody in-house, or like you said, an outside IT person you can field these questions to, it's on your radar, you're in good faith working on it, right?
So in that sense, is it similar in a certain way to like a physical barrier case that we've seen out there? There's an opportunity, there's a time period extended for you to remediate the problem.
Correct.
Fix the issues, fix the problem.
Absolutely. I mean, you've seen probably with the traditional ADA settlement, most of the plaintiffs will give you a very generous amount of time, maybe not 2 years. I didn't see those. But with these website cases, I think that at least the plaintiffs' lawyers, that we've seen down here, understand that this has to be a work in progress, that this is a new issue for a lot of people, and it's not going to happen overnight. So even though you're a person answering the phone or answering the email, they may not be able to fix it there on the spot. Hopefully they're going to be, and maybe they can. But going now to this last one, which I think is a really interesting one, because we've talked to folks, companies that got sued in other states. They've settled with the plaintiffs there, and they're working on a remediation plan for their websites, but they didn't let the world know that. And when I say the world, I mean plaintiffs' lawyers. So oftentimes we'll have clients say, so what happens if, I'm doing this remediation, I'm trying to do the right thing, what's going to prevent the next guy in the next state from suing me, or the next county over?
Sure, the opposite thinking being, if I deal with it here, then that means no one else is going to bother challenging me. But you're saying maybe, maybe not.
Maybe, maybe not. Maybe, maybe not. I can tell you with this one particular company, they were challenged again. They were sued up in New York, and now they've been sued in Florida. And one thing that they didn't do was to set up one of these accessibility sites.
But it's not these folks that we're referring to, right?
Oh, absolutely not. No, these folks did the right thing. So this is what we're looking at now, is what you guys want to consider. And I'm not saying to put up this link today if you're not working on it, but if you've gone through some of the steps we're talking about and you're trying to go the compliance route, then on your main homepage, a lot of companies are setting up what we call this accessibility statement or this link. So it's under here where we see, you know, our privacy notices, our legal notices, and Hard Rock is a good example. They got sued. They were smart, so they're working on it, and they put up one of these accessibility notices, and this is all it says. It doesn't have to be anything complicated, and the beauty of Hard Rocks is, and you can go to their website yourself or read it right here. They just put it up earlier this year, and it essentially just says that they're committed to accessibility. They're working with an accessibility consultant trying to implement the standard that we talked about, the WCAG 2.0, the higher standard, level AA, and they have a contact number, as we said here, actually an email. And essentially they're saying, please be aware our efforts are ongoing. So this is a statement to the world and maybe to some plaintiffs' lawyers. So if they see, oh, Jacey's company, they've already got this, you know, they've got a team that's working on it. So I'm going to go and I'm going to sue Nicole's company instead because
Better target.
She doesn't look like she's doing anything. So this isn't, you know, a bulletproof vest by any means, but we understand from some of the plaintiffs' lawyers that if they see this, there are so many companies that they can go after. It just doesn't make sense for them to go after companies that already, you know, might have remediated and are working on it. So keep that in mind, that this is a good idea once you start down this path. Don't forget this step. Tiffany is another example. They've taken a little bit of a different approach. Again, they have the accessibility link, but they have teamed up with this particular company, Essential Accessibility, which is an outside company. So some of our clients have found, from just a resource perspective, having their own IT people constantly handle this, because keep in mind, websites are dynamic, they're not static. You know, you're posting specials,
Right.
new products. So if your IT team, if you don't think you have the resources to handle it, you can outsource it. And this is an example of what they do. So if you were a user and you saw this icon, you would know that you can click on this link and it would provide you with the software so that you can access the company's website. So, you know, not to say it's the route you want to go, but just an idea of how different companies are handling this differently.
Understood. Okay. Any more on the accessibility pages? You've showed us that
Those
concept.
are the two we've got,
okay.
Yes.
So one of the questions that we've received is that there's been an emphasis, as you've been talking, and understandably so, about private causes of action that are going on here in South Florida. And obviously there's been some litigation elsewhere too that have been brought by private individuals who are claiming a lack of accessibility. Is that the only path by which companies are being involved in some type of litigation or regulatory process? I think you already said no.
Yeah, no.
And why be concerned about it? I mean, are there penalties, fines,
right.
fees? What's the exposure here from a pure business standpoint? I believe that's what the question is.
Sure. So the DOJ can bring an enforcement action against you. If you're a small mom and pop company, it's unlikely that's going to happen, because typically what the government will do will target a larger corporation where they can say, you know, this is a pattern and a practice. We want to set an example so that other companies don't behave the way company X is. So that, and I'm not pointing a finger at Carnival. Carnival voluntarily stepped up and entered into that settlement, but DOJ did go after Carnival for accessibility of all their boats, but it was one of the first, biggest, I should say, cases where they included the mobile apps and the websites. So Carnival did pay some, I think it was only about a $55,000, I don't want to say only, but it was a $55,000 penalty.
How do you know that? Is this
This
it's called a consent decree?
Yes, and DOJ was proud of it, and so they issued press releases, and you can go online and you can read the details of what was required in the settlement. But under the ADA and an enforcement action, it's $75,000 for a maximum of $75,000 for the first penalty, and then $150,000 thereafter. So as you can see from Carnival's number, they can be negotiated. And I think, you know, if the company is in good faith working down the path of remediation, they can. I think Carnival also paid several $100,000 in damages in addition to the penalties. So again, if you're a smaller shop, this is not likely going to be a danger for you, but do know that over the last several years, DOJ has participated in enforcement actions. They've been filing briefs in private litigation that nonprofits have brought because they're reading of the ADA, even though the statute doesn't expressly provide for coverage of websites. The DOJ has come out and said, we believe that the ADA, its purview extends to these websites.
So if you have the public forum is going to be the Department of Justice. And if they go ahead with an enforcement action, that's going to be a very public process. So we've talked about that, you've categorized that, and that certainly, from what you're saying, is going to apply to a certain larger class of companies in all probability. So now then we transition to the private causes of action that we're seeing here in the Southern District. And that seems to be a mix. That seems to be a lot of big companies and some small companies. So what's the risk from the standpoint of penalties for people who don't understand lawsuits, damages, and overall exposure in dollars and cents?
Right. So in a private cause of action like the ones that we're seeing here in South Florida, your biggest risk, frankly, is the attorney's fees and the injunctive relief that the plaintiff would be entitled to. So as with any lawsuit, any lawyer is going to tell you, you want to be able to craft the relief and the settlement yourself rather than have a court dictate what you must do. So if you go down the path of litigation, which, by the way, we are glad to do, we are litigators, and there's been many a complaint that I've seen that I think, gosh, this is sloppy. You know, I don't think that it reaches the Nexus standard. I could file a motion to dismiss. I could litigate this one. We're glad to do that. We're not saying you must settle these cases. We're just saying from an economic standpoint, sometimes it makes sense since the writing's on the wall and we think that these guidelines are forthcoming to just go ahead and start the remediation process. So you are going to be subject to the plaintiff's attorney's fees. They will, just as you might have to hire an expert to assist you, they hire their own experts. So they're allowed to collect their fees as well. And it's the same as with the traditional brick and mortar. You know, a lot of us have been through those, and the question is about, okay, how much to settle this? And you got me, because it's really, I don't want to say it's easy to find a technical violation, but most of us are not perfect. And so when you have the inspection and the experts are there, they often do find something wrong. So most people's strategy with a traditional brick and mortar ADA website lawsuit is to go ahead and just resolve this, because you don't want to be so active in litigation that you then end up having to pay plaintiff's counsel a lot of money.
Sure. And very frustrating to throw that money out and dealing with a lawsuit when perhaps you could use it to resolve what are being claimed to be barriers to accessibility.
Right.
So there's you've talked about certainly the reputational value, the business value, as well as being able to create greater accessibility and perhaps even promote that fact. And you view that as an asset that can come out of this process, whether it's a litigation process or otherwise?
Yes. So we've had plaintiff lawyers tell us, do you really want your client's company to be on the news as that company that is not catering to its disabled customers? So there certainly is the reputational value, and plaintiffs threaten that all the time, but there is some truth in that in this realm. And, as we said earlier, nobody wins except the lawyers in litigation. So if you can avoid it, it's probably your best avenue here. And I don't know if this was the question exactly, but what I wanted to make sure that I touched upon was the good business aspect. I think according to the World Bank, there's over 1 billion people on the planet who have some sort of disability. So when you are a business, you're trying to reach customers and you want to sell as many of your hotel rooms or as many of your product out there. And as we said, you don't want that person who is not able to access your website going to the next one. So from a business standpoint and a policy standpoint, it may make sense for you to take some of these issues and keep some of them in mind when you're designing your websites.
Now, a little bit more back into the weeds from another question that we received, which is websites with archived content.
Mm-hmm.
If you've done a little bit of this, if you've been exposed to this, or if you have a website with archived content, you're going to know this could be a very burdensome process, because archived content means you have a lot of content on your website, and sometimes that'll be accessed through multiple click-throughs.
Right.
Are there going to be any exemptions for that is the ultimate question.
And the answer is we don't know yet. DOJ sought comments on exactly this question. And again, this was in the Title II context, which means the state and local governments. For example, public universities, imagine if you're a research institution and you've got archives and archives and archives of educational resources. So the schools, are dealing with the Office of Civil Rights is the arm that's bringing the claims against the universities, and it's a huge issue. So we believe that there may be some exemptions for some of this archived material, especially if you can provide, alternative avenue to provide to give the individuals access to the material. But clearly, it would be a Herculean task if you have millions of pages of archived material to try to go back in time and retrofit those. So we anticipate there's going to be some leniency there.
Okay. Another question that we have, and this is no surprise, people in the business, lodging business, the restaurant business, mobile apps, big deal. Now, it's not necessarily on topic because this is a website presentation. However, maybe just to touch upon some of this and do a little nibble, can you talk about what your experience is and maybe your expectation is when it comes to mobile apps? Because I think it's going to be of value to people who are watching this.
So what I'm telling my clients is right now, most of the complaints are focusing on the company's websites. But we believe it's only a matter of time before they evolve into including the mobile apps. And as you may have noticed from the Carnival settlement, DOJ actually did include mobile apps. So there's certainly a movement there as well. And probably a lot of your businesses, particularly larger ones, have the website and then the companion mobile apps. That's where we're going as a society, is we're all using these apps. So the answer to the question is attack your websites first, because that's the most obvious target. But if you are able to and you have the resources while you're doing the remediation process, consider doing your mobile apps at the same time, because obviously it'd be a much easier process to do it at one time and get that in your budgets. But if you're able to only do one or the other, focus on your websites, and the apps can come later down the road. We don't see those as quite as pressing, although they're probably next in line.
Absolutely. Another question that we've received has to do with the internal piece. So up till now, the discussion has been the outward-facing products. But someone has asked, well, what are the implications for a potential claim internally from someone who works in our organization when it comes to interacting with items that integrate into cyber products, integrate into the cyber world, the websites?
Yeah.
Have you seen any of that yet?
So we haven't seen a lot of litigation in terms of, and this would be under Title I of the ADA, which it governs the employer-employee relationship. But it's certainly ripe for claims, because if you think about it, many of our job applications we post online. So again, if it's a PDF like we talked about before, where they need to try to work with that, or some sort of document with a timed response, these could be claims for a potential applicant to employment that they could bring. I know our company has an internal intranet where we all have access to, and these are things that companies are just now really starting to think about, because we should be providing reasonable accommodations. So we haven't seen the suits yet, probably for what you're thinking. If you've got a client visiting a bunch of retail and hotel websites, that's a whole lot easier from a volume standpoint than it is from saying he was qualified and he applied for that job there. Oh, he was also qualified and he applied for that job there. So we haven't seen that from a volume standpoint, the Title I claims, but we have to think about it. A law firm is a public accommodation. So there are discussions in lots of different places where, oh my gosh, do we need to think about some of these issues, right?
And also just kind of a blend of this. And maybe to finish off on this point, the lawyer that is leading the charge here in the Southern District also is someone who has shown no reluctance to bring a lawsuit where there is an on-site interaction between guest and a device. So as an example, this particular lawyer filed a lawsuit against Panera, claiming that the new devices that they were offering at their restaurants that they rolled out within, I believe it was the past year or so, were not accessible to individuals with disabilities, and as a consequence filed a lawsuit making a claim. And there you actually have a very interesting blending of what we're talking about a little bit, which is a technological accessibility issue also being kind of blended with an on-site physical barrier claim.
Oh, sure.
So something else to think about for people who are watching this,
yes,
I would think, is the very real possibility of taking a look at your technological operation from the standpoint of on-site.
Right, to think about your point of sales and what sort of technology you have in place there. And these lawsuits are morphing into other areas. For example, some of the complaints that we've seen are also getting into the accessibility of the privacy notices. And if they can't read your privacy notice, and then your website is going after them with these cookies, and then they didn't agree to it because they couldn't understand and read your privacy notice, your disclaimers, and all this stuff, it's very interesting to think of all the different dynamics that are at play. And again, there's some smart plaintiffs' counsel that are sitting around thinking of ways to bring these lawsuits. So again, we're not saying that you should settle them if you get hit. We are advising our clients that there are defenses that can be brought, but from a business standpoint, these are the considerations that we've talked about today, and hopefully we've provided as well some tips so that you can start thinking about with your teams how you can implement these things so that you could avoid a lawsuit, because obviously that would be primary.
Well, it's terrifying just when you thought that the boundary of privacy notices and getting those in order and making sure that they're updating and making sure you're getting opt-ins or opt-outs as necessary was resolved. Now you have to worry about a new host of issues, and it wraps into accessibility. So Nicole, thanks for all the great comments. A couple of quick points. One, I wanted to ask back to you, which is, you mentioned earlier the group that we're working with in terms of their willingness to interact with FRLA members who want to consult, or perhaps even want to take that further and work with them. Is that group willing to provide some flexible pricing to FRLA members?
Absolutely. Thanks for that reminder. The group that we're working with is providing a 20% discount to FRLA members because of our relationship with them, and they knew that we were putting on this presentation today. So for those of you that want to contact us and we can assist in that route, we're glad to.
Fantastic. One other question that did come through to us before I wrap this up is the video of this webinar. We are recording it, we will maintain it, and we can make it available and share it on demand. We're happy to do that. Again, I think the best way to get to us is to use that earlier email address, questions@rumberger.com. Nicole will get it, I will get it, and we will take care of reaching out to you and getting the information that you need. We also have a white paper on the subject that is detailed. It offers a good bit of information that we're happy to share and provide to you. And lastly, of course, we're happy to talk with you. And just because you're calling a lawyer doesn't mean the meter is running. We're happy to talk with you. We're happy to listen to the issues that you're confronted by and see if we can help you. And, if I get on a soapbox for just 2 seconds, a valued advisor who's going to cut through the nonsense and give some clear answers is hard to come by. And so hopefully we're able to play that role if you have the need, and we're happy to do it. I think that's it. Once again, want to thank the FRLA for giving us the opportunity to speak, making this content available. And we hope to be able to talk with many of the people who are listening again, and hope that the educational content of this has been of value. So have a great afternoon.
Thank you.